Thank you.
Yeah.
Taruna, can we start? Can we start,
Yes,
sir?
sir.
Yeah.
Yes, please, please.
Yes. So a very warm good morning to our guest, Dr. Rajesh Sharma, Purvi ma'am, and faculty members and all my dear students present over here for this session today. Today we have with us Dr. Rajesh Sharma, and we consider ourselves privileged to be able to host him, who is an expert in the field of arbitration. And Dr. Sharma is an assistant professor at RMIT University, Melbourne, Australia. And Dr. Sharma was the director of mooting and coach of Viz Arbitration Moot at City University. He has also designed the International ADR Moot Court competition run by the City University. This moot is unique in the world because it combines arbitration and mediation, where a student also takes part in as a mediator and not only as a mooter. So Dr. Sharma has taught courses on arbitration, mediation, negotiation, foreign investment arbitration, WTO law, international trade at Hong Kong, Macau, India, Australia, China, and Africa. And so as we all know that arbitration as a dispute resolution mechanism is gaining greater significance in the contemporary times, especially during these pandemic situations wherein the commercial organizations are looking forward to have a speedier recourse to their dispute. And all the most because of this pandemic, we are starting to move towards the online arbitration portal as well, which also begins with, or it also brings up a lot of pressing issues and questions. And today's session will be on the integration of two ever-evolving streams, that is arbitration and intellectual property. So as of now, no country or has been able to come up to a standstill on these two particular legislations. We are still evolving. We are striving to improve on daily basis. So with this note, we start hoping to find answers for several pressing concerns and questions. I once again welcome Dr. Rajesh Sharma and all the participants. Over to you, sir.
Thank you. Thank you very much. I must thank Dean and Head Professor Pokhariyal for inviting me. And I should say that, and I was telling her before we started, that I wish I were the students of Nirma University and taking part in this program and being taught by international experts. In the line of experts which I see, I don't consider myself up to that standard, but it's so kindness of them that they have considered me to come before you and share my experience or knowledge. I won't say knowledge, it's just a sharing of my experience, which I can come up to you and do that. The reason I selected this topic, and Taruna was very apt on that point to pick it up, that generally we look at either intellectual property separately and we look at arbitration separately and we do not combine. However, in our practical life, if you look at the professional life of arbitrator and arbitration, particularly investment arbitration and commercial arbitration, intellectual property is coming every time. And the reason it is coming is because the intellectual property is considered as one of the elements of foreign investment. And it's one of the component. Foreign investment is not just only the money, but it's also related to technology. And the technology can be invested too. And the transfer of technology can also be asset. So on this note, it is coming all the time. But either we are finding the people are expert in arbitration or they are expert in the intellectual property, but very few people can combine it together. And such kind of people are required and such kind of a study is required. Another thing is that particularly for students of Nirma University who are taking part in the Viz International Moot this year, the issue of intellectual property is also involved over there with the sale of goods. And that is also become interesting issue. But that was not the reason. Mooting was not the reason, though the mooting is in my heart all the time. And I have been taking part in the Viz Moot for last 23 years. And I have been coaching and directing and all those things. And I successfully coached the team which won the Vienna Championship, also the Hong Kong Championship. So yes, those things are there, but this is not about the mooting alone. The another thing is that the issue is so developing that recently I have been appointed as a chairman of the Hong Kong Commercial International Arbitration Center, particularly to head the chairmanship of the IP group. And our mandate is to develop the IP dispute. And it's not only for Hong Kong, we want to develop for everyone. And Professor Pokharial has seen me know the newly established Asia Pacific Arbitration and Mediation Center is also focusing on that. So for students, we want to tell you that something coming up in the future. And if you consider yourself, you are going to be a professional, not only for India, but for internationally. So you need to get ready for that. And over the time, in 5 to 7 years of time, this field is going to open for you and it is coming to you. So get ready for that. And that's the idea behind it. And therefore, the most the confusing part in the IP dispute resolution through arbitration is the concept of arbitrability, where people or everybody thinks that IP disputes cannot be arbitrated. And there is a reason behind that why they think that this cannot be arbitrated. And I will tell you that arbitrability is something that we look at in a negative way. We say that what cannot be arbitrated. And this is the non-arbitrability is the issue. And basically, we put it in a word, we say that subject matter of dispute incapable of settlement by arbitration. Means there are certain disputes which cannot be arbitrated at all. And the common example you can see, criminal dispute cannot be arbitrated. But when we look at the commercial side of it, the intellectual property being a commercial side, but it has been left out of the arbitration for a long time. And this has gone and this has become such non-arbitrable issue. It's a very simple reason, because the intellectual property rights, particularly those which comes from the registration like patent and trademark, it is given by the government. Once the government gives that, then the person acquires the right or the company acquires the right, and then they enforce against the world or against anybody. So therefore, it is considered that the person who is giving the authority, that's the person who is right for determining the dispute if it happens. Then later on, what happens, it was also connected to the public policy. It said that if the authorities are giving this, then it's the authority who will decide. And if anybody like arbitrator, the private body cannot decide this issue, it will be against the public policy of the country. That was the idea. And it has all started because of the judiciary or because of the judicial process which was there long time back, and the arbitration as an ADR process, as an alternative to court process, it shifted from there. So it is a tension between the court and the private judicial function or private dispute resolution function, which created this inherent problem in arbitration, which we have been facing for a long time, but slowly it is coming up. Basically, it is a control of the government and the control of the judiciary on certain matter. Otherwise, if you look at that, everything, whatever we want, we can arbitrate. I mean, it's all depending on the situation. So we focus on this part. I want to give you the historical context that why the arbitrability of the IP disputes was always, or not just IP dispute, but why arbitrability matters. The very first, I'm looking at the international level. I'm not looking at the country level. If you go to the country level, even the UK Arbitration Act, which is very old, which was applicable in India, they also have these phrases that what can be arbitrated, what cannot be arbitrated. But if you look at in the international context, we see that the first you will find it in arbitration field actually is 1923 Geneva Protocol. And that protocol was on the arbitration clause, where the arbitration clauses were enforced at that time. And in that one, the word appears, it says that all the subject matter about the dispute, about the arbitration, everything was said. But the word which was added is this, that it said that all the related to commercial matters or to any other matter capable of settlement by arbitration. And if you look at that, it was phrased in a positive way. But arbitrability means that anything which can be resolved through the arbitration. So that's the phrase it was added. But then after that, what happens? That we come to 1927 of Geneva Convention on the Execution of Foreign Awards. This is the predecessor of the New York Convention on Enforcement of Foreign Awards. In that one, the very first article, Article 1, and the second ground, a stand-alone ground, was written over there that an award cannot be enforced if the subject matter of award is not capable of settlement by arbitration in the law, in the country where you are enforcing. So basically it says that if you bring an award and it is against the arbitrability, or against it is in India, for example, in India doesn't consider that subject matter as arbitrable, then you cannot enforce that award here. So this was the first, like, for the foreign award, it was added over there, and it was kept very high up in the list of the grounds. And that was Article 1B, and it was a standalone ground. It was created over there in 1927. And then we come to 1958, when the New York Convention happened. So let me tell you, 1927 to 1958, of course, when the New York Convention was discussed, the first draft was given by the ICC. And the ICC wanted this draft to happen. And they, of course, after World War, when they wanted to have arbitration, and they come up with this idea of how to enforce the award. And the New York Convention came in that one. And Article 5 to have A and B paragraph, it was added, the arbitrability part and as well as the public policy part. Interesting was when the New York Convention was negotiated and when it was discussed, ICC gave the first draft. Then at that time, there was no Uncentral, it was ECOSOC, which took up this idea and then did the further study. And then they come up with the draft. And the draft was exactly the same. The two articles were given over there until the second last draft. In the second last draft, what happened, that arbitrability issue, or this ground 5.2a was deleted, and it was just left public policy ground only. And the public policy ground, the reason it was kept over there, it was a very simple reason, that if a country's law does not allow certain dispute to be arbitrated, then that becomes a part of the public policy. So basically the public policy and arbitrability are nothing but the same thing in a country for a particular country. So therefore the public policy subsume the concept of arbitrability. And therefore, they say that ignore the arbitrability part and just have one ground, public policy. And guess what? On the very last, second last draft, it was France which objected and said that no, public policy will be confusing. The reason they were saying public policy will be confusing, because in arbitration, we want to apply international public policy, not domestic public policy. That is the consensus. However, if we look at arbitrability part, we are looking at within the country, what a country allows to arbitrate or not to arbitrate. So it's a domestic public policy. So they say that if we just keep one public policy, it might be confusing. So let's make it two. And there was, and you will be surprised to note that no member objected to that. They just accepted. They said that whether you separate it or put it together is all same. So they didn't make any noise, any problem in that. And then the grounds were again separated here. And that's how we have got it now, two grounds. Otherwise, we do not have to discuss about this arbitrability. We would have been discussing this issue under the public policy matter. And this is what it changed. And perhaps it has changed as a blessing in disguise for us. And we will discuss that one, and I will tell you that why it happens. In that one, the one thing is that the court can take care of this issue on its own. On its suo motu, parties do not have to argue. They do not have to prove. The court can look into this issue directly under its own. Very recently, this matter of arbitrability has come under a scanner or come under discussion again when the Uncentral has recently drafted the Singapore Convention. Singapore Convention is about the enforcement of mediation settlement enforced in foreign countries. That convention also says that when a mediation settlement cannot be enforced or cannot be executed, in that one also they say that if the subject matter of dispute is incapable of settlement by mediation, incapable. And you will see that the word over the periods, subject matter of dispute which is capable of being arbitrated has changed into incapable of being arbitrated. So the incapable of settlement by mediation, and the new word which has now we have coined is mediability. Arbitrability and mediability. So this issue has come and it was just taken from the New York Convention. It's a very simple. Again, why it was done? Because same in New York Convention and the Singapore Convention, all the governments, they always want to have the court and judiciary and the government want to have the trump card in their hand, that something which they do not want to execute, they can do it either on the basis of public policy or on the basis of arbitrability or mediability. And that was the converging, that was the consensus point in New York Convention also. That's why the government in 1958, they signed that, they approved it, and now they are using it. But that was the time over there. And the Singapore Convention, which has just become effective from 2019, we are using it. Actually, it has become effective from September 2020, and it was signed in August 2019. So this issue is there, and we continue with this issue. Then moving forward, we see that at that time, why the arbitrability and New York Convention is there. There's a Professor Vandenberg who is still very authority in the arbitration, and also he is the first one who did in my information, he's the first one who did the PhD on the New York Convention, and he was doing he was looking at the record and everything. In that one, if you see in his view, he said that the arbitrability of a subject matter, it requires and it reflects a special national interest, same like public policy, and we say that it is the interest of judiciary that they want to keep control, or the state wants to keep a control. And then what happened that during the drafting of New York Convention, they were looking at that what are the examples of non-arbitrable matter. And in that one, they definitely come up with some issues, which was a consensus at that time. They say, for example, antitrust issues, intellectual property issue, family dispute. They say that all these things will be considered non-arbitrable. So then the question came that why not we prepare a list of non-arbitrable issues, and so that we include in New York Convention or in other laws, so it will be very clear for parties and the countries that what is arbitrable, what is not arbitrable. But that idea was not accepted. The reason it was not accepted, because what a country will decide as an arbitrable or non-arbitrable, it should remain with the country, because we have to apply the local law of that country when we are enforcing the New York Convention, or when you are enforcing the foreign awards. So therefore, it was left to the countries, and countries like that part. But what came very clear in that one is the intellectual property rights were considered that it is non-arbitrable issue. So that was very clear in that one. And we continued with this clarity since 1958. And again, as I say that it is a state control. But what is more important, it came in the discussion that everybody agreed at that time that when we say that IP the intellectual property rights are not arbitrable, meaning the subject matter of that non-arbitrability or subject matter of IPR dispute should be the central issue. It should not be a peripheral, it should not be an incidental nature. It means when we are talking about the ownership of patent, trademark rights, then it should be trademark rights and nothing connected to anything else. So the incidental nature or incidental involvement of IPR will not make it non-arbitrable. It has to be the central issue. So that was a very clear distinction it came. And we continued that idea of incidental nature. If we look at that, in 1980s also, when the CISG, the Convention of International Sale of Goods, when it was agreed, in that one also, the intellectual property was considered as a peripheral right. And that law was basically related to buy and sell of property. And in Article 42, it was said that the seller must deliver the goods which are free from any right or third-party right, and including intellectual property right. Meaning, even in 1980s, when the technology was not that high, advanced, still they thought that whenever we buy and sell the goods, with the goods, the technology or the IPR are always involved. So what happens if the IPR dispute happens at that time? Would it be considered as a central dispute, or would it be considered as a peripheral or incidental dispute? And CISG continued with this, and it just required at that time as an incidental, issues of intellectual property. And therefore, arbitrators who have been doing this, dealing with the sale and purchase of goods, and whenever the technology or whenever the IPR involved, they didn't dwell upon the issue of IPR as such. They just look at a prima facie case or a strong case that somebody is asking or somebody is challenging that the technology or the patent or the trademark involved with the sale of goods is belonging to somebody else, and therefore this sale is contaminated or tainted, and therefore the sale is not complete, and therefore the compensation happens. The tribunal never went into the issues that who owns the trademark, who owns the, whether they own validly or not, and whether the patent was given validly or not. So they didn't look at the ownership. So that's how the peripherally it was dealt until 1980s. Then we move forward, 1985, when we have an Uncentral Model Law on arbitration. In that one, in the footnote, the word commercial, and remember the CISG, the word commercial was not there. So there was no need to define the word commercial. But in Uncentral Model Law, there was a word commercial involved. So there was needed that we should define the word commercial. And in the footnote, it was decided and defined. And it said that there should be a wide interpretation should be given to that. Wide, how wide, we have no idea. But it was said as much as possible, because we said that arbitration can happen for the commercial dispute or any dispute, any legal relationship, whether contractual or not. And it has to be decided, it has to be related to like commercial. So if you look at any contractual relationship, whether contractual or not can have so many other kinds of relationship. But what here they said that relationships, they give some example, but they added the word, but these are not limited to, means there was opening was given to us that we can interpret the commercial dispute in a wider way. But if you look at all these examples which has been given here, goods or services, distribution agreements, factoring, leasing, financing, banking, all those things, if you look at that, joint venture is also there, but there's nothing about intellectual property. Its word was not included. It means the idea of intellectual property as a commercial matter was not there even in 1985. So they ignored that part and it was not included. While it was already involved, or already happening all the time. The reason Uncentral Model Law has to control, because in Article 34 and 36, they had the New York Convention provision, which says that award can be set aside if it is against the arbitrability of the state or the local law, or it is against the arbitrability as applied in the place where the enforcement is sought. So because of that, the commercial law interpretation cannot be wide, and therefore arbitrators never interpreted it wide, otherwise it will go against the internal law, and therefore it will be inconsistent, and that is not acceptable. So 1985 model law was the time when we could have done it, but it was not done for these reasons. But then there was a shift that started happening. From late 80s to early 90s, we saw that intellectual property started coming on the forefront, and we had to deal with it. In US, particularly, it was a very strong move over there. In Switzerland, Belgium, there was a strong move over there. Particularly in the US, Mitsubishi case, which was an antitrust case, but the technology was also involved, and that was in 1985, and the US court said that, yes, it is arbitrable. You can arbitrate it. So basically in US, it's a very wide approach. Everything commercial can be arbitrated, basically. But major shift we saw also in WIPO, World Intellectual Property Organization, which is the leading organization to deal with the intellectual properties. Even they established a WIPO Arbitration and Mediation Center in 1994. And it means they wanted to focus on not just a commercial dispute, their main specialization was on the IP dispute, and they were using ADR mechanism, both arbitration and mediation. It means those IP disputes could be arbitrated, could be mediated, and therefore they took this approach. And by the way, my first arbitration training or the induction was by the WIPO Arbitration and Mediation Center. I was one of the first few batches of when they started the training program, I was in the first batch of that. And we were taught by very top arbitrators like Vandenberg, David Plant, and all those. And we talked about the IP dispute at that time. So it was a very interesting part to see that. But if you look at the cases over the period which WIPO has decided the cases, you will find that the WIPO has dealt with mostly a commercial agreement, like a licensing agreement, or the parties themselves have an agreement that who will use trademark and where they will use, how they will use, and there was a dispute on that agreement, and that's how it went to WIPO. So it was not a directly trademark ownership or patent ownership question. It was a commercial arrangement which was made between the parties, and that was under dispute, and it was treated as a commercial dispute. Only one or two cases where the WIPO has dealt with the ownership of patent. And of course, it was Swiss government was involved, and since they are in Geneva, so they had a very nice relationship. So they handled that case very well, and that was with the parties' agreement. It went to the WIPO, and the ownership of patent was discussed over there. So slowly we saw that the ownership of trademark, ownership of intellectual property rights, for example, can be arbitrated, can be mediated, and WIPO took the lead in that one. Fast forward from then, what happened in recent developments which has happened, and I look at the two countries, Singapore and Hong Kong. The reason I'm looking at it, because these are the Asian countries and we should focus on that, and there is some resemblance we have to see in India. The reason I'm looking at Hong Kong and Singapore, because they compete and they are the centers of, like, the dispute resolution. They call themselves as a hub of dispute resolution. And particularly, I was in Hong Kong for more than 20 years. So I'm like, connected to that. So that's another point. But what is more important to see from these two countries to learn about it, that they have taken the lead. Hong Kong and Singapore, they did a kind of, they set up the working group to see that how the IP trade, because of digital trade, because of the international trade, because of the involvement of technology now, they say that how we can make our center, our arbitration center, or Singapore as a country, how we can make as a hub of IP dispute resolution center. So every country is setting up the arbitration center to become the commercial arbitration center. They wanted to have more than that. And they wanted to have, we have established ourselves as a commercial arbitration center. Now we should establish ourselves as an IP dispute resolution center. Very unique concept. Even in US, we don't have that kind of a thing. So a working group was set up and they all agreed that yes, it can happen. It will increase the trade in digital trade, and as well as it will also help the country, help the parties to resolve their IP related disputes. And they all come up with the idea and they say that yes, these two countries can be promoted and developed as an IP dispute hub or the IP dispute resolution center. They also say that we can use IP arbitration and IP mediation, we can promote. And they say that then we can create a study group and see that how the amendment in law can be done so that we can facilitate IP dispute. And with that one, they combine with the local experts and other, and they come up with the idea. And what they did, they changed their law. And actually the study was done by Singapore first, but the Hong Kong did the change first. And the Singapore has just done last year. Hong Kong did in 2017. It's a very simple changes has come. In the same arbitration or law or the ordinance, they have added extra paragraph and just made it clear. Say, for example, they have said that the IP dispute is arbitrable. As simple as that. The moment they say that IP dispute are arbitrable, they say that IP dispute is not incapable of settlement by arbitration. So they use incapable and they added the word not. So do negative, make it like arbitrable. So it's a simple thing. Then they also made one very important change, that they declare in the law itself that the enforcement of award or IP related award will not be considered against the public policy of Hong Kong or Singapore. Otherwise, what would have happened? That even if it's arbitrable, court can use the public policy to deny the enforcement, or they can set aside the award. So they made it very clear that this is a public policy, that IP dispute can be arbitrated. So it was a significant development. Otherwise, the court would have been interpreted in one way or the other, and it could have gone everywhere. So that's why it was a very good decision to add it like that. And that was the experts' opinion also, that we should do it. Then what we did, learning from the New York Convention, they made it and said that, look, whether the IP dispute is a main dispute or incidental dispute or indirect dispute, doesn't matter. It is all arbitrable. And incidental one is very important. Main is also important. So now what will happen? A commercial arbitrator, when he's handling the case of sale and purchase of goods, which involve the ownership of technology or ownership of IPR, he can also decide on that. So that expands his jurisdiction, and that makes it very important. Then it also says that it doesn't matter whether your other laws, whether it's IPR law or any other law, it says that whether those disputes can be decided as an arbitrator or decided under any tribunal or any special tribunal or appeal or like by the authority. So basically they say that it doesn't matter what the other law says, just follow the arbitration law. If arbitration law is saying that it is arbitrable, then even if the patent law says, even if the trademark law says that it is not, it will not matter. The arbitration law will trump. And this is jurisprudentially, if you look at that, arbitration law is a law, but basically it's a procedure law, which is now trumping the substantive rights of the parties, which is in the IP dispute and all. So this is a very interesting part which has happened, and therefore we can say that the same kind of a thing we have seen in Switzerland, US, Belgium, all these places. You will find that the arbitration is doing, or that IPRs are arbitrable in that one. And then the law has gone further and it has decided that which are the IP dispute we are talking about. And they put it very nicely. They say that dispute over enforceability, infringement, subsistence, validity, and important part is ownership. And this is the ownership was never coming under the scope of arbitrator. The moment the ownership came, it became very wide, and now we can have all. And then they did not give an exhaustible list. They said that open it for interpretation that any other aspects of an IPR. So now think about that, any other aspects in future, if we have a more development, we can still consider that and we can include it in those disputes. It's also said that the dispute over any transaction related to IPR, whether there's a trade of IPR itself or anything, we can still do that. With the digital trade, it will be very important for us to see that. Any compensation, like compulsory license or any kind of like, it has been issued, just the money part also can be done. And this is, we can see the relationship with the FDA, the foreign arbitration or foreign investment arbitration, where the countries can, or the government take or disturb the IPRs, and then they offer the compensation. So only the compensation part or the money part can also be arbitrated. So this is very good. And like any commercial dispute, now in this, we can add it as a future dispute resolution clause in a contract, or we can also have a submission agreement like for the current dispute. So it opens a wide door in that one. And the both position of Singapore and Hong Kong are the same in that sense. This is just a list of IPR that which they have already put in law, that what are the things. And of course, the patent, trademark, copyright, these everybody knows. But very few people know that even geographical indication can be there. Like in India also, like, Jaipur Juti, like, for example, it was only for Jaipur, like, and Lucknow's kurta, like, is that one with the very, or Tanjavur sari. All those things are capable of, like, geographical indication. That dispute can also be resolved, which is a new one, like, you can see that. And then layout, design, circuits, all those things, if you look at plant variety, everything is there. Goodwill and passing off, those things are there. And again, non-exhaustible list has been given where it say any other intellectual property rights of whatever nature. So now this can cover everything which comes in there, and you will see what can be covered over there. If you see the Mohamed Salah, who is the very famous football player, he got good money for playing for club, but he also, the club was using his photograph. He challenged his club and said that, no, you cannot use my photograph. And if you are using my photograph, then you have to give me more money because it's a publicity right is with me. Same like Gita Jones and Michael Douglas, when they married, their photograph was published by newspaper. They said, no, this is our publicity right. You cannot publish those photos. You have to pay the compensation. Similarly, different photographs are published in newspaper where we've always filed a case of defamation. But think about it, as a lawyer, we can now change the case of defamation, and we can also make a case of intellectual property rights related to that, any other rights which we have, and we can have a publicity right, our face, our photo, we can use on that one. So this any other IPR of whatever nature is very good. But what is more important is to classify that which kind of rights are there, all the registrable IPRs like trademark and patent, and already all other IPR which are subsisting, for example, copyrights and any other. So everything is covered. Most importantly, even the application for filing the registration for IPR is also your IPR related dispute. Otherwise, what would happen as a trademark and as a patent applicant, you will lose your priority, and therefore this has been included. So it's a very good way they have handled it, and it's very up to date on that one. Then what happens if the arbitration conducts and then award is given? So who are bound by this award? Generally, in these two countries, they have come up with the idea that only the parties to the arbitration will be bound, which is like an arbitration, because like a contract, like an arbitration, only parties will join over there. But in IP disputes, we can have so many licenses, exclusive license in different countries. So what will happen to them? It generally said that no, they are not party to it unless they join as a joinder, or we join through a party. So that's why joinder can be a good solution for that, and we can include that if you want. But then they said that every award might have a problem later on for the third party, for example, exclusive license or licenses or any other licenses. If they have got the licenses from a wrong IP holder, then their license will be wrong, and therefore there will be impact. So as a lawyer, you need to, when you are arguing this case, you need to make an argument, and as a matter of prayer of relief, you should include that the decision of this award will also be affecting or also be involved the third party, or for example, like the license holder. So therefore you can do that. Then also interim orders in the dispute is very important, because if some wrong person is using the trademark, we have to stop them first. Otherwise, by the time in 1 year, 6 months time, when the award will come out, it will be very difficult to stop them. So they said that tribunal has a general power of now giving the interim order. So even the IP disputes, or in the case of IP dispute, they can give an interim order, and that can be stopped. So there's an interim order provision is also there, which can be done in that. Another problem which or might happen is that in these two countries, they don't want the IP authorities to be bound by the arbitral award. So assuming an arbitrator decided that this award has wrongly, or this patent has wrongly been given to a party, it should be given to the other party. So what will happen? It should happen that we go to the country, we change the ownership, and the register of IP department should reflect that. What they have said, that although IP authorities are not bound by that, but in their general perception, they have said that they will in general be bound by or in general, they will follow the decision of the award. So in a soft approach that has been created for Hong Kong and Singapore. But in US is very upfront. US has said that if you have that award, go and register this award with the IP department. But over there, then you have a control of IP department, which says that, oh, they will allow you to go and enforce or not to enforce. So there might be a problem. So in both ways, we will have a problem. And that's the difference at this moment, or that's the loophole we find, that it is not helping us. It should be binding on everyone, and that should be the final outcome of that. So that's the one is there. Very simple, that award will have what happened to the award. It cannot be set aside only on the basis of IP dispute. Award cannot be refused because of arbitrability of IP dispute. Award cannot be, and for such kind of award, we can't even use the public policy ground to remove that. We cannot do that. So basically, our foreign awards will be easily enforced without any problem in these jurisdictions. Another thing is that we can also ask for a declaratory award, meaning we can have a declaration from the tribunal to say that who is the owner of trademark. And that again is a very good decision we can have if, like, we can follow that. So, and we can also ask the tribunal to limit themselves only for the enforcement or only for the compensation. Anything we want, we can limit them. But that's a party's autonomy of arbitration, which we can do it without any problem. But the only problem is that what will happen to these awards? Can we really use the New York Convention to apply everywhere? New York Convention is effective in more than 160 countries. It is impossible. Only US, Belgium, Switzerland, Singapore, Hong Kong, these are the countries which consider IP dispute as an arbitrable. So at least in these places, we can get it enforced. Is it useful for us? It is. Perhaps it is useful for us. For example, an Indian company has a problem with the American company, and they choose Singapore as a place of arbitration, then they can get an award and enforce it in US. But even if the we have to enforce it in, like, say, for example, China or India or any other place where it is non-arbitrable, we don't go to that country. We will wait for that. And the losing party, we will wait for them where they have money, where they have bank account, where they have property. We can go and do that, particularly in these 4 jurisdictions. So at least it's a good start, which we can consider, as long as it's not violating the public policy in this country, and there will be no problem to that, then we can do it. So I was looking at that, the whole idea that this country will become the hub of IP dispute center, have they satisfied that? And I should say upfront that I don't have a data of Singapore, because Singapore had just adopted in 2019. Their 2020 report is not out. So, and of course it was effective on that one, so it's not available. But I just looked at this Hong Kong one. If you see in 2016, before the law became effective, their classification is that they had total 262 cases, arbitration related cases. And in that one, the IP dispute was only 5.4%. 2017, when the law became effective, the number of cases is 297, but the IP dispute is only 4.6% of that one. In 2018, it was 265, and the IP dispute is only 1.8%. And 2019, 308 cases, but it's only 2.5%. So does it show that we are increasing, or it is becoming like most of the cases are coming? It's up and down. And also we are not clear at this moment that IP dispute, whether they have not classified whether it was related to ownership or not. That will make it clear. They might be looking at IP dispute as a licensing agreement, which was always there as a commercial dispute. So we don't have, but we see a good trend over there in that. Now, in the COVID time, we have seen that the COVID-related vaccine which has come, we are seeing that the IP-related dispute might become very much. Only because of the COVID, people are holding themselves. For example, in Italy, ventilator was running short. So some of the people or the company, they started using 3D printing and they started making the oxygen ventilator. When they made it, the original company, they said that I will sue you, stop that, because I don't want you to violate my patent or my intellectual property rights. So even in the COVID time, there was a threat. Same like, Pfizer and Oxford Zenka, they have a dispute. In Korea, they were having a different variation. And actually, Pfizer stopped them, that you cannot make it. And all those things, if you look at that, and many countries have given to the other party and said that, well, it is because of COVID, I'm stopping from taking legal action. But the moment the COVID pandemic will finish, I will sue you. Then it means the other company has to pay the money back. So this kind of a dispute we are seeing, and not only that, we also see that it's a direct vaccine-related IPR we are talking about. But a new IPR is also developing, is related to the vaccine-related one, related to development, related to production, and related to delivery. And a classic example, you must have heard that Oxford Zenka, AstraZeneca COVID vaccine, they say that you have to keep it in minus 80 degrees centigrade. I mean, which container can really hold minus 80 degrees centigrade? For that, we need a special container, a special provision. So even for the delivery process, they have asked for the patent on that one. And so far, we don't know how many patent applications have been filed, because most of the countries have 18 months of embargo period, that when the assessment is going on, we don't know the decision. But some of the NGOs, they have found out that Oxford has applied in 13 jurisdictions. And if it is approved, then they will be valid for 2031. And in UK alone, they will get it from 2037, it will apply. So we know that about the Oxford Zenka, but we don't know about other vaccines and other variants of that, or other process and everything, we don't know. But all these things are lying around like a minefield, and it will start very soon. The dispute will come. If we leave it to the court, then every time we have to go to the court, and that will have another problem. India has recognized this problem. And India with South Africa, they have gone to the WTO, and in recent, in discussion in TRIPS, they said that why don't we suspend the TRIPS? Meaning, if we suspend the TRIPS, like trade-related intellectual property rights, means patent and trademark is all involved there. If we suspend it for a while, then no company or vaccine company can go and use that, and they can register. It means it will be widely available to everyone. So as a generic medicine, we can prepare and we can deliver, because at that time, public health is more important than the commercial intent. That's the idea behind it. And of course, developed countries have stopped that, and they not stopped, but they have challenged it. But as a developing country, as India and South Africa, they have realized that. They say that, look, we are not saying that suspension is a silver bullet. But what it says, that during the COVID time, we have found that IPR system is not helping us to deal with the pandemic. And therefore, we have to consider again. But that being said, IPR is a different issue. Here we are talking about arbitrability. But what does it say? It says that this COVID vaccine related disputes will increase, meaning the IPR disputes are going to increase very soon. And so many disputes will come. So how we are going to take advantage of that? Hong Kong, Singapore, US may take an advantage because they are IP hub, and they have already said it's arbitrable. But what India can do? India at this moment, we don't have anything to really deal with it. So the one very least we can think about, that change the arbitration law and make IP dispute arbitrable. And for that, at this moment, I think NITI Aayog is taking the lead for all the policy related discussion. Maybe it's a good place to give them, because very recently NITI Aayog also came up with the online dispute resolution. And because of COVID, they become very active. And I was fortunate that they asked me for the comments on online dispute resolution. So maybe this is the first call we can have contact the Niti Aayog on that. Otherwise, if you look at the Indian courts and we look at arbitrability, it's very difficult because the courts always interpret in one way or the other. And very recent decision of Vidya Drolia case where they have given fourfold test of arbitrability. If you look at that, it is really very confusing and I'm not sure how it will be applied. But so therefore we say that it should be in law. Another positive side, if you look at that in in India, we have a commercial courts. Recently, the commercial division has been set up over there. In commercial division, the jurisdiction has been given on IP dispute also. So the interesting part is that now the IP dispute, India consider is a commercial matter. And if IP dispute is a commercial matter, and if the commercial matter, as per law, there is a mandatory mediation has been recommended. So assuming the parties have an IP dispute, they go to commercial court, but according to law, they have to go to mediation. So what they will be mediating? Mediating this IP dispute. And this is, if you look at indirectly, we have a pathway in India to proceed in that direction to really make it viable. And in that sense, it is a good idea that now India is considering IP as a commercial dispute. And that brings to the idea that should be a stop here. If it is, we are the countries which are making it arbitrable, should we move forward and make it mediable also? And that's the general course we can say that, yes, that's how they should go about it. And Singapore Convention has already given the word mediability. And if in the mediation law, we can say that arbitration dispute can be mediated also, then that's fine. And the example which comes from Hong Kong and from the task force and Hong Kong and Singapore, they say that if we are going for that, then generally we use facilitative mediation. But for this purpose, we can also use evaluative mediation, means a decision kind of a thing will come. So the ownership will be decided. So in that case, we can use it. And WIPO has been the example for a long time to deal with mediation and arbitration. So I think that's a consequence. So if India is looking at it, then they should do it both, arbitration and mediation at one time. And by the way, India is a party to signatory to the Singapore Convention. So they have to adopt that, and this is the right time to do it. And the reason I'm saying, you must have seen the new case between Apple and Pear technology. Apple challenged this one. Apple also challenged this one. Of course, the court decided that it is not confusing. So Apple almost lost the case. And Pear technology, they won the case. We knew that Apple and Pear cannot be compared. We knew that from our childhood, but Apple was complaining about it. But final solution, what happens? It came through the negotiation or assisted negotiation. And what changes has come? Simply, if you look at the leaf of this Pear has been now, earlier it was full circle, now it has become half. It's such a minor change that even we cannot pick it up if we see with naked eyes. But Apple considered as a big leaf because Apple has here the leaf like this, Pear has a leaf like this. So just cut it half and they are happy with that. I don't see anything anywhere. But what it shows that even for this kind of a dispute, we don't have to go to arbitration even. We can do it through the mediation. And that is the idea that we should be following in that and take advantage of full ADR in our situation. But while these things will happen in India, should we just keep quiet? Answer is no. And particularly the Nirma University should take the lead in this situation where the lawyers, patent and trademark agents, we are teaching only law, but you should also consider those patent and trademark agents, small and medium-sized enterprises who have less legal resources. We are not worried about the multinational companies. We are not worried about Jio and Adani. They can manage it, no problem. Tata Group, they can manage it. But these small and medium-sized enterprises, lawyers and students should be given a special training on that one so that they can include dispute resolution as an IP as a parties agreement, they can do that. Arbitrators should be given a specialized training the way the WIPO does, particularly on the IP dispute, so that the arbitrator, not just an arbitration training, but they should also do that. And most importantly, the law student. And I heard from you that you have an ADR center and you also have an IP center. Now, if you can combine together, you can give the IPRA students some idea about the dispute resolution through the ADR means, and ADRA students to learn about that, how a particular type of dispute can be resolved. If we combine it together, this is specialized training, then it will be very good. And it is happening in US and it is happening in Switzerland. And NIRMA can take advantage of that or take the lead in that. And the WIPO is always there to assist you on that one. And it can be done. So in conclusion, I can say that IP dispute, the growing trend says that the IP dispute will be arbitrable and it should be mediable also. It should be there. Though the Hong Kong and Singapore has taken the right step, India should also consider and could consider the similar, because we are also focusing on digital trade, and that will be very helpful to us. So we can do that. So globally, what we see that it's time now that we also declare that the IP dispute is not only arbitrable, but is mediable also. And that's how we can complete the circle of ADR and we can go. So thank you very much for your time and attention. It's really a pleasure. And thank you. Thank you once again.
Thank you so much, sir, for such an enlightening session. And we did find the answer to many of our questions. But we have two questions over here. One is related to arbitrability of the ownership of intellectual property rights. So the question is that the ownership of intellectual property rights is given by a state authority or by a state government. So whenever we are looking forward to arbitration of this kind of an ownership dispute, how can we use it as a tool for the dispute resolution, or how can a private entity be involved in the dispute resolution of ownership of IP? Whereas that private entity was not involved while granting or ensuring the enforceability of that particular ownership.
It's a very general question which has been we have been discussing for a long time. That is the point where the governments right from the beginning, they say that IPR disputes are not arbitrable because we grant you the right. So therefore we will decide who are you. And particularly it was also that those 2-3 people who are acting as an arbitrator, who are they? That they will give us, they will tell us that what is right, what is wrong. So again, it's a mindset. So similarly, we can say that how come the arbitrators can decide $1 million dispute? Why not the judges? Then how come we decide that in foreign investment, where the, if you look at Australian plain packaging case, or if you look at all the WTO dispute where the money is involved, government is involved, how the panel is deciding? The idea was that long time back when it comes to arbitrability, particularly in the anti-competition disputes, the idea was that the private person are not capable to do the proper investigation, and therefore it cannot be done. That is not right. And if you look at the court, how many times we get the judges who are deciding the IP dispute, they are really expert in IP. But just because they are just, they are deciding. But if you look at an arbitrator, we can choose the top IP lawyers and an IP expert as your arbitrator, and they can decide. And in WIPO, these cases are deciding. So it's not about the who is granting the right, and therefore that person will decide. It's not that. The issue is that if that dispute happen, can you give it to somebody else who can do it? And now it is considered, even before the state authority decide, in the appellate mechanism, because even the trademark and patent authority will decide, then you have a right to appeal. In that appellate model, now they are setting up and private entity or private people are coming as an arbitrator and expert who will give the decision objectively. So that's the idea. It's not about who gives the right. It's about that whether these people can decide or not. That is the main question. And we say that arbitrators can decide, and therefore it should be arbitrable. And think about it, what Singapore, US has been doing for so long, Switzerland is doing for so long, Belgium is doing for so long, and Singapore and Hong Kong are doing for so long. So do you think that over there they have not considered this issue? Of course. So this is now we are breaking away from the tension of the judiciary, the control of judiciary and state. And Hazel Fox is a very great authority, and she said only thing, any time when we see the problem in arbitration, it's because the arbitration has developed as a subservient to judicial process. So we always compare to judicial process. That's why our mindset is not moving. Even the Singapore Convention, everybody said, how come a private agreement or private contract can directly be enforced? Many people, I can tell you that many experts, I mean, I was involved in the drafting. I was involved in the Uncentral process, so I know that. But even outside, even now, like, they say that we cannot digest that, we cannot understand that how a private settlement and private agreement can be enforced. So it's a mindset. It's not about the authority. It's about who are capable to solve that. That's the thing.
So the next question is from my faculty colleague, Dr. Bishwa. He is saying, dear sir, do you think that employing blockchains in form of smart contracts of IP agreements would fortify the arbitrability of IP disputes and facilitate in due course? And if this could be a general practice or an exception?
It's a good idea. Like, the artificial intelligence, blockchain, all those things will give us, like, for example, the information which we are putting over there, it will be confidential and those things. And of course, it is just a tool which will help us. But the question of arbitrability cannot be overcome by using blockchain or like artificial intelligence, because it's a matter of public policy. Doesn't matter what technology we use, whatever the like, the black like blockchain or AI technology we use, particularly blockchain, it will not help us if the law says that it is not arbitrable. And that's the problem. The moment we clear that, then it doesn't matter how we do it. And actually, patent information doesn't have to be confidential. It has to be open. And that's why if you want to know the technology, you can go to the patent office and you can see it. So yes, that can be a good tool to really use it. And particularly the blockchain and other will help us to see that who filed when, what is their technology, where there is a similarity, where there is a dissimilarity. So it will give an authority to decide, or any person who is deciding whether patent should belong to this person or that person. And the COVID variant vaccines which are being developed at this time, that will be very useful to use this technology. So it will be a good supporting technology, but legally we have a problem of arbitrability, which can only be solved through the legislation.
So now I have a question that's on my behalf. Yeah. So as you just mentioned, I mean, when we were discussing about the Apple and the Pear case, you just mentioned that there is no likelihood of confusion that might arise. And such a kind of situations or such kind of cases can be resolved through mediation as a first step towards resolving the dispute rather than directly going for arbitration. So when we study the WIPO dispute resolution tools that WIPO uses, there is a very interesting tool that they have, which is early neutral evaluation also. So would it be very appropriate if we can make it mandatory, especially with respect to IP infringement matters, that we ask the parties to first go for early neutral evaluation and then seek for mediation or arbitration? Because there can be matters which can directly be resolved at the stage of early neutral evaluation itself, and there might not be a step arise for going for arbitration altogether. So what is your stand on that?
No, certainly, like, as an ADR expert, I think that any mechanism which can avoid the dispute or prevent the dispute or resolve the dispute is all good. So early determination or early expert determination is also good, because we are inviting the expert to have a look. And actually, WIPO has a very nice technology, like, and because of the tools and technology which we have now, earlier when we were given the training, we were using the transparency and the projector to see the diagram and everything. But now we can really have a 3D image. We can go inside the equipment to really see the design, really see everything. So those things are there now. So these are the things any authority will do. And these are the things any expert will do. And that's how they can give their early views on that. And that will help the parties to say that, look, if we are going ahead, then that's what it will happen. So that is a good start. I like that, and we should use it. The only problem in in WIPO is one thing, is that they still believe in one policy, is that if somebody has infringed your intellectual property rights, he's more like a theft. It's more like a thief. And now we are asking the owner to negotiate with the thief. That's again, it's a mindset and technology part we are looking at it. It's not that it has not happened. It has happened. The two parties have agreed that, okay, you use the same trademark in one country and I will use the same trademark in another country. They have done that kind of a deal. So idea of that, and then making mediation mandatory, I will very much support that. And I like that idea. And that's what I was linking. If you look at the commercial courts jurisdiction in India, IP dispute is part of court jurisdiction. But then they said mandatory mediation. So isn't it is a mandatory already that if you have an IPR dispute and you are going to commercial court, then you go to mediation. But the only thing is that they don't agree on the mediation and they just do the eyewash. That's not good. As long as they do it in good faith, then it will work. And the Apple and Pear technology case is very important in that one. Ultimately, after the court decision, it was their private negotiation, assisted negotiation, which has reached to this conclusion. They have not followed the court decision. They have followed their own agreement. Otherwise, Pear technology didn't have to change. Why they changed? They didn't have to. They won the case. What was wrong with that? So yes, all these ADR technology, the mediation was not used before because we didn't have the mechanism of enforcement. Now with the Singapore Convention, we have this mechanism. And this was discussed. It was all this discussed that how this Singapore Convention can facilitate in future. And even the investment dispute, even the technology dispute, all kinds of dispute now can be mediated and it can be enforced. So why not?
So one last question we will take from one of another faculty colleague, Dr. Shalini. Sorry, it's a student who has given this question. So her question is that the infringement disputes are arbitrable in many jurisdictions. However, the issues relating to validity of IP disputes are not arbitrable. What is the reason behind the same?
The same, because the validity, the ownership, the validity or ownership which we are talking about, that we have to decide that who is the right patent holder. So that's the thing we have. And particularly for the patent is also like now we have a global patent system that you file a global application at one time and it's dealt with some of the agencies. The reason it was there again, the idea was that it's the authority which grants this right. So is the authority is in the right place to really investigate, assess, and then evaluate, and then decide that whether it should be granted or not. This power was never given to the arbitrator. But if we have the way the authorities are deciding, the way arbitrator can decide it too. So that's why we have to look at it. And the part which we are talking about, the validity and other, part, actually, if you look at those cases, most of the cases has been converted into a commercial arrangement. For example, it's a licensing agreement, whether it's exclusive or non-exclusive licensing agreement. That licensing agreement has a terms, or even the the agreement to write together or agreement to develop something together. So they already have a pre-existing agreement. So when have a problem related to IPR, basically the courts or the tribunal are going back and looking at that agreement. When they look at that agreement, they consider as a contractual terms. And what they are deciding on the basis of those contractual terms, not on the basis of IP itself. So IP becomes in that case an the incidental matter rather than other. So we become more like a contractual matter. So this is the difference is happening. And that's why you find a licensing agreement, validity, whether the licensor has done this one, breached the agreement or not. Those are the issues are going, but they are not looking at the ownership. But the changes which has come in Hong Kong, Singapore, US, Switzerland, now the ownership can also be decided by the tribunal. And that will make the authority and the tribunal together and on par. And then it will solve all the problems.
Yeah. Thank you so much, sir, for such an enlightening session. I would extend my heartfelt gratitude on behalf of the Institute and Dr. Purvi ma'am, as well as on my personal behalf. And now I would like to call our student representative, Aishani Kothari, to extend the vote of thanks for this session.
Hello and good morning to one and all. Friends, it's a matter of immense pride and privilege for me to propose the vote of thanks on this momentous occasion. Lucky are those who get the opportunity. Brilliant are those who create opportunity. But winners are those who use the opportunity. And it was our privilege today to have such a winner amidst us. On behalf of Institute of Law, RMIT University, I wholeheartedly thank Dr. Rajesh Sharma for accepting our invitation and delivering such an insightful session on the arbitrability of IP disputes. Thank you, sir, for taking us through the timeline which led to arbitrability and emphasizing on the fact that the incidental nature of IPR will not make it non-arbitrable. I would also like to express my gratitude towards our Reverend Dean and Director at Institute of Law, Professor Dr. Purvi Pokhriyal, for organizing the International Teaching Month for the students in order to provide them with a global insight towards various trending legal issues. I would also like to thank Taruna ma'am for being the moderator for today's event and ensuring the smooth flow of this virtual webinar. No event is complete without the never-ending support of the technical staff. I take this opportunity to thank the technical and the support staff at Nirma University. Last but not the least, I would like to thank all the professors and the students for their active participation and patient listening throughout the event. Thank you one and all. Have a nice day.
Thank you very much.
Thank you,
It was a
Aishani. Thank you so much, sir. Hope to host you again. And it was a great pleasure listening to you and hope to see you soon.
Thank you very much. I'm the winner that I took part in this. Thank you.